Welcome everybody. We'll just wait for a few more people to join us, then we'll get underway. Right, we'll get underway. Thank you very much for joining us today. Kia ora, I'm Philip Aldridge, Executive Director from HASANZ, the Health and Safety Association of New Zealand. We're an umbrella body looking after 14 associations, looking with people that work in workplace health and safety. Today's topic is emerging trends, legal trends in health and safety. So we've got 3 or 4 things in that, and Olivia Lund from a partner at Duncan Cotterill will be presenting. I'll hand over to her shortly to present, but we've got talking about emerging trends, case law, update, some information about COVID-19 and potential learnings for Whakaari or White Island. Just in terms of the format today, so we'll have myself do a bit of introduction, then we'll have the presentation for about 30 minutes, 40 minutes, and in the middle we have an opportunity to ask questions. And we'll have Q&A as well. So if you look at the bottom of your screen, those who haven't used Zoom before, along the bottom is your Q&A function. So throughout the session, please put in your Q&A and we'll endeavour to answer all those throughout the session. And we'll be sending out a copy of the presentation and the recording tomorrow. Just one thing before I hand across to Olivia, those of you who may be interested, there's a HASANZ conference is coming up in the 1st to September, 1st to the 3rd of September in Wellington, Te Papa. It's quite a good conference, so go onto our website and have a look. Olivia will be talking there as well, and Duncan Cotterill will be sponsoring us, so great to have you there if you can make it. Now I'd like to pass across to Olivia.
Great, thanks Philip. Kia ora koutou, hello everyone. It's great to connect again with you all. As Philip said, I'm going to break out the session today kind of into 3 or 4 topics. First of all, I'm just going to give an oversight into some emerging trends, and that's really kind of a recap on recent stats around fatality levels, lost injury time, percentage of fatalities, which industries they're linked to, WorkSafe's approach to investigation and prosecutions over the last year. Then I'm going to touch briefly on COVID-19 issues, and there are a lot of them, but the focus today is really just going to be on what we see clients now coming back to us and asking for further assistance. A key one at the moment is the COVID-19 vaccination and how to manage that in the workplace and with their workers. I'm then going to talk about a couple of cases, so really only talking about notable High Court decisions. One of those is the Civil Aviation and Sargison High Court case. The decision was late last year, but only was released earlier this year. That discusses what at work means, and also how you calculate reparation and consequential loss for financial lost earnings. And then the other case, which some of you will probably be aware of because it's been out for some time, is the first court ordered enforceable undertaking, and that's the Otago Polytechnic case. And just some oversights and views that I kind of have to share on that. And then lucky last will be just to give an update on the Whakaari White Island prosecutions, and from my perspective what potentially, depending on how those prosecutions unfold and what the defendants decide to do, if they plead guilty or not guilty, what learnings we might take from those prosecutions. So moving first on to emerging trends. So what we have seen since HASWA has come into force is fatalities have decreased, and that was one of the goals of WorkSafe and the task force in HASWA being implemented, but it has really stagnated in the last few years. In 2020 we had 63 fatalities. The one concerning factor though that is also a key factor which WorkSafe are looking to improve is the serious injuries and lost time. So the time away from work due to serious injuries has actually increased in the last 10 years. When we look at the number of fatalities, 1/3 of them are in the agricultural sector, so that remains a high focus, critical industry and sector which WorkSafe are focused on. And then not surprisingly there, 70% of fatalities are linked to vehicles. WorkSafe, I think, is faced some criticism, and there's been teething issues with HASWA that's come into force as between the functions of WorkSafe, NZTA and police, and particularly when there are vehicle incidents that potentially relate to work, who takes authority over those investigations. So I think we are still to see improvements that need to be made there between those various organisations, and unfortunately COVID and Whakaari White Island investigation and prosecution has distracted or taken some of those resources away from WorkSafe, which I think would have been put towards the roading transport accident sector. So the number of investigations, and this is another area which WorkSafe have been criticised for, have significantly dropped from 2016. So what we saw, and I've got a slide coming soon which will have the stats set up in bar graphs, but what we saw in 2016 is there were around 30 investigations opened per month. In 2020, and of course we had COVID, so that would have impacted on the number of investigations that inspectors were able to do. That dropped to around 13, but it's not actually that much of a drop from the year before when we didn't have COVID, which was 15 in 2019. Despite the number of investigations significantly dropping, prosecution numbers actually still remain quite steady. So we see around 60 to 70 prosecutions a year. From my perspective, the cases that are investigated by WorkSafe, so they decide to investigate, they do tend to kind of lead to a higher proportion of charges being made and prosecutions followed. My observations in terms of how investigations now look is they are a lot more onerous and cumbersome on the parties involved. WorkSafe's approach in the inspection process is much more thorough than it used to be. I've shared stories with various clients 5 or 6 years ago when we would have a duty holder interview. It may have run for a couple of hours. Now it's not uncommon for duty holder interviews to take 3, 4, 5 hours, sometimes longer, to go through that workplace's entire system, and they tend to be months, at least 4 to 6 months after an accident has occurred, because WorkSafe will be following lines of inquiry, which generally will be interviewing employees, witnesses to the accident, going supply chain, looking at industry practice, and then they will usually conclude their investigation process with a duty holder interview. The average range of fines imposed, so there is some thought that they have been reducing in the last couple of years. In 2018, they were up to 285, and we're talking about average fines, so not allowing for the discount for financial incapacity to pay. Last year, I think the average fine was just sitting over 200,000. So we're not sure why that is, but there is a little bit of drop in the average fines that are being imposed. So on this slide here, there's obviously some bar graphs showing in detail the number of investigations, the number of successful prosecutions and enforceable undertakings. Notably, you can see there the number of investigations in 2016, that's the first year the Act came into force, is up to 356, and then 2019 to 2020, 135. So a significant drop there. Another figure that stands out on that page for me is the enforceable undertakings. So we saw quite a flurry within the first couple of years. Enforceable undertakings were a new initiative that wasn't available as a sentencing or an alternative to sentencing enforcement tool available. So in that kind of second, third year, we saw quite a number of applications being put through and that were accepted, but that has actually started to drop off in the last couple of years. And my impression is that it is really difficult for enforceable undertakings to be accepted by less sophisticated and resourced defendants. So the ones that we do tend to see accepted tend to be the kind of larger corporates better resourced, they're able to deliver work programs that are going to benefit not only their own organisation but the wider industry. So this is purely my view, but I think it's harder for when you've got smaller operators or smaller businesses where they don't have those resources available to essentially kind of meet the requirements. You know, it is difficult, it is onerous to achieve an enforceable undertaking and have it accepted, let alone have to implement it. So I'm not surprised that we've seen those numbers drop off. The other thing on that slide is the amount of enforcement measures. So there's also not on this slide though the number of assessments that WorkSafe have been undertaken, and that's not covered there, but that has been significant as well. So WorkSafe would say that they are focusing more of their attention in doing workplace assessments, engaging with business and organisations to make sure that they understand what their obligations are, rather than going down the enforcement path. And that might be why we see a drop-off in investigations being conducted, with WorkSafe diverting their resources to more assessment-based interactions with industry and business. So COVID-19, obviously that has been a significant issue for everyone to deal with in terms of health and safety, risk management and impacts it's had on the workplace and workforce. What we're starting to see now is issues arising with changes to the workforce. And what I'm talking about there is the actual workers available to do the work. So with less migrant workers, we've got clients in the agricultural, horticultural sector that don't have the capacity needed because of the restrictions on migrant workers not being able to come in. And what that has then had an influence on is that we then have untrained or unexperienced workers from other areas now working in these new work areas where they are not experienced, they're untrained, but they're also working within a business where there is significant demand on the other workers. Those workers are working long hours to kind of get the work done because there is a shortage in the workforce. So there is stress, there's fatigue, there is additional impact and risks that are now become more present that we may not have seen in the same situation if we didn't have the borders closed off. The other aspect that we now have clients coming to ask questions about is the whole kind of working from home, remote working, flexible working. During COVID lockdown, there was some lenience around, you know, having policies in place or having sufficient working from home set up. It was the environment right, was the workstation right, because there was not a lot of time to react, and it occurred suddenly without much time to plan. I think that excuse around the urgency and the lack of resources is not going to stand up anymore. So what we do have is actually a mixed approach. We have and see some clients now who are concerned about, you know, mental health and well-being of their teams and wanting them to bring them back into the workplace to make sure that they have that kind of team bonding, wanting to improve kind of culture, concerned about isolation. So we have some people who are wanting people to come back to the workplace, whereas others are actually now have enjoyed the working from home, and so they've got workers who are permanently making arrangements to permanently work from home, and also some large corporates and big organisations now that are actually reviewing their workspace required and are reducing floor space, and they are going to look at a model where they will have their workers working from home on a permanent basis. So the whole way in which we work has been flipped upside down. And what we're now looking at is, well, how do we manage risk? What are our obligations when we have workers working at home permanently? Who pays for the cost of working from home? Who pays for the assessments to make sure that the work desk or the workspace is ergonomic and it's set up correctly? Who provides all the resources to work from home? Is it the employee if they want to work from home, or if they're directed or required to work from home now, is it the employer? So there's all these sorts of questions that are coming up. The other aspect that we see is the mental health and wellbeing. That is obviously a topical area, but it's an area that organisations are conscious of, wanting to engage in, wanting to upskill in. And I know that HASANS has got a series of webinars that they are hoping to hold, and one of those will be on, mentally healthy working and mental health in terms of risk management. So I won't touch on that in any detail, but I just wanted to give some insight as to these are the types of issues that are coming out of COVID-19 that clients are coming to us for assistance with, and that we'll be looking to people like you in terms of professionals and practitioners operating in this area. COVID-19 vaccinations. So that is a topical issue at the moment. Obviously, there is a priority list as to who gets the vaccinations first. I think the general population, it's scheduled for June or July this year. Now, what I'm being asked is, is there a requirement for workers to be vaccinated? And can businesses or organisations make vaccinations mandatory? Other questions are, surely making vaccination mandatory would be providing the highest form of protection against COVID. So isn't that something that we should be doing under HASWA to meet our reasonably practical obligations there, our primary duty? So the first thing that I say in terms of COVID-19 vaccinations is that, one, they aren't mandatory for the New Zealand public. So the government haven't made that as a requirement. The final decision as to whether someone gets a vaccination or not rests with the individual. So there is a strong expectation from government that employers and business owners will assist and encourage workers to be vaccinated, but you can't have a blanket rule that requires your workers to be vaccinated. So if we step it back a little bit, there are a number of issues to consider when you are managing COVID-19 in the workplace to make sure that you do that properly. The first one to be conscious of is that any vaccination is regarded as a medical procedure. So people in New Zealand have the right to refuse a medical procedure, vaccination, under the New Zealand Bill of Rights Act. There are also grounds upon which they may refuse that vaccination. That may be for health or medical reasons, due to pregnancy or some other medical health reason, or for religious beliefs. So there are a whole bunch of issues employers need to be mindful of when they are engaging with their workers as to whether vaccination is going to be strongly encouraged. There are privacy obligations to consider as well. So you can't, you need to be careful not to breach a worker's privacy. If they decline to be vaccinated, you need their consent to then disclose that to other workers in the workplace that they aren't vaccinated. There is a mixed view as to whether you can make it a condition of a new role. So there are some employment lawyers out there who are of the view that for your current workforce, you can't make it a condition of their employment to require them to get a vaccination. You can, however, require the role, so not the person, to be performed by a vaccinated person. But until you get to the position where you've deemed a role necessary to be carried out by a vaccinated person, you would have had to have conducted a risk assessment to determine, well, why is it that that role needs a vaccinated person doing that? There would be health workers, borders, people travelling overseas potentially, and you would need to have carried out an assessment as to why the standard controls in terms of minimising exposure to COVID are not sufficient. In terms of new employees, though, just finishing off that thought, there is some employment lawyers out there that are saying, well, actually, you can, for new employees, make it a condition of their employment that they are required to be vaccinated. However, when you are engaging in that recruitment process to appoint an employee into that position, you would need to be careful so as to not breach their rights, which I was talking about earlier around, well, what are the reasons why that person doesn't want to be vaccinated, and ensure that if you don't then offer that person employment, that you aren't discriminating on the basis of one of the unlawful grounds. Is it because of religious beliefs that they don't want to be vaccinated? So to be able to rely on a health and safety reason as to why someone needs to be vaccinated in New Zealand, we would, in my view, need to have wider and sustained community transmission to make it justifiable on health and safety grounds for vaccination to be mandatory. There will be a high obligation that if you have workers, or if you yourself are a worker and don't want to be vaccinated, the organisation is going to have a high obligation to consider alternatives rather than terminating. So are there other roles that they can carry out? Are there changes to their work that they can do which mean that they don't need to have a vaccination? So just summing up kind of the vaccination, it is to treat carefully. If there is a health and safety risk in terms of exposure to COVID-19 that needs to be managed properly, organisations are going to have to carry out a risk assessment to require a role to be carried out by someone vaccinated. It's not mandatory for the New Zealand public to be vaccinated, but there is a strong expectation by the government that employers will assist its workforce to be vaccinated, and that will include providing the workforce with proper and sufficient information as to the benefits of getting vaccinated, potentially making arrangements to vaccinate your workers at the worksite, and also allowing them time off, paid time off, to go and get vaccinated. So that is something we're all, most of us are going to be going through in the next few months, if some of us already haven't been vaccinated. So just moving now on to case update. So I'm not going to go through a whole bunch of cases.
Olivia, do you want to stop there for any questions?
Oh, yes. Yeah, sorry.
So if you've got any questions, just pop them in the Q&A function around those two topics. There's obviously time at the end too, but if you've got any questions, just fire them in straight away. Just one question I had, Olivia, is around the vaccinations. How would people go about, well, I suppose it depends on the industry, I suppose, and the sector, the occupation. There has to be some assessment of what the risk is, presumably, the risk to themselves and to the other colleagues.
In terms of having it justified as,
you know, and would there be different levels saying this is a mandatory role, this is strongly preferred, this is optional, for example, to get vaccination?
Yeah, so the difficulty that I have is where we don't have community or sustained transmission in New Zealand, and we've had people carrying out these roles for a significant period of time now, it's going to be very difficult to say, well, there's a health and safety risk and we require you to be vaccinated. It's different if you have got someone who is working, say, in an MIQ isolation facility, or they are, you know, at the border, and so they are actually being exposed potentially on a day-to-day basis with people who may be infected with COVID-19. But for the general population who are not working in that space, I just don't think it will be justifiable. Where we then have potentially the border restrictions loosened, and we may see you know, a higher proportion of the population that is vaccinated, and we have people who are infected, and this might be a year or two down the track, then there may be a different assessment in terms of risk then as to, well, what is the requirement here? Are there any vulnerable people? What is that person's role? What's the makeup of the workforce? How many people are vaccinated? All of those sorts of things would need to be considered.
Yeah, on a personal note, actually, I had a friend who's got a girlfriend in Auckland, and he goes up there all the time, and his employer is actually putting pressure on him to not go to Auckland. Actually, it's quite interesting. It's quite almost an employment matter, because I think part of the reason is because there's someone at work who's a diabetic or at higher risk. So there's those sort of situations which makes a lot of things tricky as well.
Yeah, and that in itself has questions around personal, you know, for work. If someone is carrying out a work activity, then the employer has more control and influence over what they're doing, but you can't really direct someone in their personal life as to where they can travel and what they can do. That's more problematic.
There's one question here. Is it expected that employers will cover the costs?
No. My understanding is they'll be fully funded by the government, so they'll be free. In terms of time off to get the vaccination, the government has made strong indications that employers should facilitate that where they can, and so large organisations with big workforces are actually thinking that this is going to be better if we facilitate mass vaccination on site, rather than having their workers leave the work site and then have to go somewhere else to be vaccinated. So it'll be more efficient and cost effective for them to facilitate it themselves.
There's one question here which is slightly unusual. What about the issue of no evidential foundation as whether the vaccine works? Perhaps I can answer that. I think, Olivia, you can chip in, but MedSafe are looking at all the evidence around the world, and they are rolling out the vaccines that actually work. So, and we're lucky in some sense that we're slightly behind everybody else, so we can actually view the stats, what's coming out. One question from Tracy is, if a worker is providing care to a vulnerable group, would that create a mandatory vaccination scenario?
Yes, potentially, and it also creates difficulties in terms of privacy obligations. So let's say you were a vulnerable client, you might want to know, is this healthcare provider vaccinated? So then you can make informed decision making as to treatment by that person, but then the employer will have privacy obligations in not disclosing the vaccination status. So it's going to be very difficult to manage everyone's competing privacy, legal rights and obligations in that situation. But you would want to be engaging with all the various parties and making sure that there is proper understanding, that there is informed consent, and that you are managing everyone's privacy and legal rights fairly and appropriately.
Here's a good one, Olivia, for you. What if an international client that in our case is holding an event with 2,000 people has written into their hire contract for the venue that all workers have to be vaccinated or they can't be work on that day?
Is this offshore?
Yeah, basically a procurement requirement that people that work have to be vaccinated.
In New Zealand or overseas? Where's the event in New Zealand?
I presume it's New Zealand, yeah.
Yeah, look, well, our human rights legislation, our New Zealand Bill of Rights legislation would apply. So again, you'd need to be careful that you're not breaching your legal obligations in New Zealand. Depends on where the event is being held, but there's all those discussions that are now taking place overseas, particularly sporting events where they are requiring, athletes to be vaccinated, and whether that is a breach of human rights or excluding those people. So yeah, it's a grey area.
It is New Zealand, yeah.
It is New Zealand, yeah.
Perhaps we have one or two more questions and we can move on. What about duties of care, i.e. reducing public contact for employees who decline a vaccination, especially the significant risk factors with the nature of the original work?
I'm not sure of that question.
No, we'll move on. Perhaps you can rephrase the question, whoever wrote that one. In an instance where an employee is traveling to Auckland, can you insist that person work from home, especially if you have a medically vulnerable person in the workplace? Probably that personal example where someone goes to Auckland for whatever reason. Can you insist on them working from home afterwards?
Because you have vulnerable workers that you want to then protect. So well, look, it would depend on what's happening in Auckland at the time. Is there actually community transmission ongoing? What is the risk in terms of infection and then transmission back to whichever city that you're in? So it needs to be based on actual risk assessment, evidence-based, but then also you're going to have dual obligations to your vulnerable workers to make sure that they are protected and working with them. But also the other worker who is travelling as well, so not as to disadvantage them in their workplace. So it's consulting with all parties and trying to balance it fairly between all of them.
Yep.
But we do see that a lot, particularly even with our own organisation. You know, there's some down south, and then we've got our Auckland people who are dealing with more lockdowns and community transmission. So there is kind of heightened anxiety around that. And the government has guidance on that as to what you need to do, when to do it at the various alert levels.
Okay, one question, then we'll get you moving on again. There's a question here which I'm not sure if it's true, but why is WorkSafe now investigating workplaces that have had the vaccine process but workers declined?
I'm not across that, so it's not something I'll be able to comment on, sorry.
Okay.
Right, okay, I'll move on to the two cases I just wanted to touch on before we get into Whakaari White Island. So I just wanted to touch on that we are now starting to see kind of these officer prosecutions be brought. Maritime New Zealand has brought a couple of them, and Civil Aviation and Sarginson. So prosecution against officers is rare, and where we tend to see WorkSafe, or the other regulators, in this case Maritime and Civil Aviation, taking action is where it's a small business where the officers are working in the business on a day-to-day basis. So they are significantly involved in the operations, they're across the activity, they are across the hazards and risks that are arising in their workplace, and they are not meeting their officer due diligence requirements. So the first case that I wanted to talk about is Director of Civil Aviation in Sarginson. So this is was appealed from the District Court, and why I'm highlighting this case is there's two parts to it. One, the case considers the meaning of work, and secondly, it looks at how we calculate reparation for consequential loss of earnings. So in terms of the at work component, this was a case where a worker died. So Mr. Sarginson's business partner died in a helicopter crash, and the argument that was made is that they were essentially just using the helicopter to commute to a place where they were going to carry out work. The helicopter was overloaded, and there were decisions made around weather conditions that meant it was unsafe and shouldn't have been flown. And so the legal issue arose as to whether those workers were at work by using the helicopter as a means of transport to get to a location where they were then going to carry out work, agricultural work. So what the High Court had to look at was, well, what is the purpose of HASWA? Is it intended to encompass all activity, and including travel that arises or is for the purpose of work? Or is it actually just looking at what are the risks and hazards that arise out of the activity or work that PCBU is doing, so their business or undertaking? What the High Court did in this case is that it decided that the purpose of HASWA is to encompass all activity. So if the purpose of the travel is work, and we're not just talking about a commute to work, then workers will be at work, and the risks that arise from the travel will be subject to HASWA duties. And there's a nice kind of discussion in the case which explain what the requirements are, and I'll read this out. So the lawyer acting for CAA gave an example of how this duty would apply. So if a PCBU is arranging for an employee to use their private vehicle to drive a co-worker for work purposes, the PCBU in that case would be obligated to make inquiries of the employee's driving record, their experience, whether the person's licensed, whether the vehicle was warranted, and that essentially would discharge that PCBU's obligation to ensure the health and safety of its worker, who is going to be transported by its worker so far as reasonably practical. How they then contrasted that is with arrangements involving a worker. So let's say if you had a worker that was in an unlicensed colleague's car, you didn't know what their driving experience was, you'd had made no inquiries as to the roadworthiness or warrant of fitness of the vehicle, and the vehicle wasn't roadworthy. In that case, the PCBU would unlikely to be able to discharge its obligation in terms of taking all steps as far as reasonably practical to ensure the health and safety of its workers. So that was kind of an analogy in this case to say, well, in this case, Mr. Sargensen was using his personal helicopter. He was a worker of that organisation to transport another worker for work purposes. So in that case, there was a breach of the duty because there was a failure to assess risk and ensure that there was appropriate controls in place. The court in that case did comment on if you were looking at, booking travel arrangements for workers, and you're booking, say, someone on Air New Zealand or Jetstar, a commercial operator, that would be enough in itself, because the PCBU can rely on that commercial entity in terms of being a safe operator. You don't then need to make inquiries of that person. But if it was a smaller outfit or a worker using their own vehicle or their own mode of transport, the obligation is more onerous in that position, where they would then need to take steps to ensure that that mode of travel is safe and that there are sufficient controls in place. The other aspect of Sargensen, which I think has reopened the whole discussion around how we calculate reparation awards for loss of earnings. So the sentencing, just to kind of bring everyone up to the same page, the sentencing process under HASRA involves two parts of it. One is a fine that's usually imposed, and then a reparation. So whenever there is a fatality, there's two parts to the reparation generally. One part is for emotional harm, and that generally sits around 100, 110,000 that is awarded to the deceased person's family. And then there's also a consequential loss component of the reparation, and that can cover, say, property damage or changes that someone needs to make as a result of the accident, funeral costs, those sorts of things. But the big ticket item is generally the consequential loss of earnings that needs to be paid. And some of you will be familiar with the Oceania Gold case, which was the High Court case which determined how we calculate reparation for loss of earnings. And the High Court in Oceania Gold took a limited approach, and they said, well, that is to be calculated using the statutory shortfall approach. And that is the difference between the amount that the victim, person, or their family would have received in income and compensation payable under ACC, and it's limited to the period that they were entitled to those payments. So it's the shortfall and the difference. And what that meant was that essentially for the family of a deceased member, it was restricted to 60%, say the spouse or a partner, 60% of 80% of that deceased lost earnings up to a period of 5 years. And then the child could claim 20% of the 80% lost earnings till they reach the age of 18 or 21 if they were engaged in tertiary education. Now, what we've seen the High Court and Sargensen do is they didn't actually change the sentence that was imposed in this case, but made comments essentially saying that there's no cap on what can be ordered for consequential loss. So this essentially statutory shortfall approach in Oceania Gold, according to the High Court and Sargensen, wasn't upheld or followed. So reparation, it was confirmed reparation can't be ordered for consequential loss which has been paid or will be paid for ACC entitlement. So there's no double dipping, but there's no cap on what can be ordered for consequential loss. So it's not limited to the shortfall in entitlements under ACC. It can actually go up to 100% of what that person's earnings may have been. So Oceania Gold took the statutory shortfall approach to provide consistency and a clear kind of method to calculate what the consequential loss of earnings would be. I think what we're going to see now is that that door is now open, and so we might now see actuary evidence, and the judge in Sarkinson was very clear that it's not a set rule. So the court needs to have discretion for the case and the defendant and the victim in front of him or her as to, well, what are their circumstances, what actually is the consequential loss of earnings, and we shouldn't be tied in this regimented prescribed calculation process. So I think we're going to see actuary evidence being provided. I think reparation awards are likely to increase as a result of the Sarkinson's case. The second case that I wanted just to touch on briefly, and there has been quite a lot of coverage of this case, is the first court-ordered enforceable undertaking. So this is the Otago Polytechnic case, where there was a student who was using a draw saw and partially amputated their finger. The saw had been used in the Polytechnic for 30 plus years. I think 1970. It was unguarded. Interestingly, in this case, Otago Polytechnic had actually sought to go through the voluntary enforceable undertakings process with WorkSafe, but that was actually declined. And so in this case, what we saw is that the court was open to an enforceable undertaking being imposed, but it was onerous. And I think, in my view, it is reflective of the defendant that we had before the court in this case. So one, we have essentially a Crown entity, Otago Polytechnic. The requirements of the enforceable undertaking required them to design, deliver and offer training programs and education programs in the construction sector. And so this was something that Otago Polytechnic, being an education provider, was well placed to provide. The estimated cost of the program was $275,000, and that level essentially indicates what the fine would have been if Otago Polytechnic was otherwise sentenced in the usual way and a fine was imposed. The aim of the program obviously was to enhance health and safety knowledge. So you've got similar kind of takeouts as the voluntary enforceable undertakings process, where you've got your own organisation is going to benefit from the enforceable undertaking. There's wider benefits, education aspects to the wider community industry in which you're operating. So that met all of the requirements. I don't think we're going to see a lot of court-ordered enforceable undertakings. I think just like the EU's, it is a high threshold to meet, and it has to be the right defendant that is sufficiently resourced to be able to meet the requirements for a court to impose a court-ordered enforceable undertaking. In this case, the factors I think that went towards that being accepted was the victim was supportive of the undertaking. They were an educator. They essentially had a system already to be able to create and deliver the content of the training as a Crown organisation, so kind of money going to one organisation to the other. And it also met those compliance and improvement requirements. So yes, it's the first court-ordered enforceable undertaking. It took a lot of work. There are ongoing compliance obligations on that defendant, 6 monthly reviews before the court where they will need to engage, update the court on where they are at in terms of meeting the requirements. So we'll see how that unfolds. Are there any questions here before I move on to Whakaari, White Island and the prosecutions?
There's a couple of questions around fatigue, but maybe and sort of the difference between commuting versus work, but perhaps we'll come back to those at the end.
Yeah, okay. So Whakaari, White Island, as most of you will know, this was the largest investigation and prosecution ever taken by WorkSafe, and probably its predecessor, the Department of Labour. I think around 25 inspectors were assigned to the case, and when you look at the total makeup of inspectors within WorkSafe, I think it's around 160 roughly. So a large number were assigned to the case. 10 PCBUs have been charged, and then 3 individuals as directors have been charged. The officers, directors that are being charged, they are of the land management company, essentially the landowner who have allowed people to carry out business on White Island. So the way I see this prosecution is a system-wide approach. So essentially, WorkSafe have looked at all of those that have been involved with White Island and tourists going to White Island as an adventure activity across the supply chain. So we've got, you know, the landowner, we've got the officers of essentially the land management company charged, we've got government agencies, departments who have been providing risk information and undertaking assessments of the island being charged. We've got the ticket and tourist operators, we've got the helicopter operators. So it is the full system-wide supply chain in terms of adventure activity that has been carried out at White Island. To dispel some kind of confusion as to the charges, so the charges only relate to action that was taken prior to the eruption. So not the actions that any organisation or individual took in emergency response or rescue efforts. In terms of where we're at in the court process at the moment, my understanding is that there have been no pleas entered to the charges. WorkSafe is still going through the process of providing disclosure. So essentially all the information and documentation that it has in support of the prosecution to the various parties. There are procedural issues that are being discussed at the moment, and that essentially is as to where the charges were laid and where the hearing is to take place. The charges were laid in the Auckland District Court, and there is a view that actually they should have been laid in the Whakaari District Court because that is closest to where the event occurred and where the defendants are located. So that is a procedural issue that the court will need to determine as to where the hearing takes place. My take on it is that I think that there will be some parties who definitely defend the charges. The hearing will be significant and it won't be until next year. We're probably talking about at least a 3-month hearing, and given the significance of the issues at play, that's likely to be, you know, potentially could be appealed through the court system. So it may be some years until we get clear and reliable precedent. In terms of potential learnings though, that I think that we can get and hopefully that we get out of WorkSafe, is what we see with cases going through the court system at the moment is not a lot of them are actually being appealed on terminology under HESWA. You know, what does it mean in terms of overlapping duties? What are the 3C requirements? What does it actually look like in practice? What does reasonably practical look like? Does someone actually have a duty in this situation? What we do see in the appeal decisions going through to the High Court is the sentencing outcomes. So what I'm hopeful is that we will get some precedent from the Whakaari White Island prosecutions, particularly on the duties of landowners. So there will be, I think, discussion in this case as to, well, landowners have control and influence as to who goes to the workplace and under what conditions. And in most of those cases, you'll see, you know, license agreements, lease agreements, contractors, contracts with various parties. And look, it's not uncommon for those contracts and agreements to essentially detail the responsibility of the other parties that are coming on to the land as to what they are required to do in terms of risk management. And in this case, it may be that that is seen as essentially pushing down your responsibilities as to other parties. Even though you may have clear, expressed, defined roles, responsibilities, who's doing what, there is provision under HESWA that essentially those provisions have no effect. I think we will hopefully have some kind of consideration as to, well, what is a landowner in this situation required to do in terms of compliance and obligations if you do have duties set out in contractual agreements. What is the action that's required to be taken if you've got a contracting party that's not meeting their obligations? What do you need to do if you as the landowner don't have suitable experience or expertise in terms of the activities that are being carried out? And one of the kind of key takeouts that I have taken from the charges and reading them and the summary of facts is that the message is that if you are not suitably qualified or don't have sufficient expertise in terms of risk management for what is occurring in your business or undertaking or the supply chain, you need to engage with people outside your organisation. So, I'm hoping that we do see clear kind of authority as to what are the duties of a landowner in this case. Interesting, looking at the officer obligations here, they looked at, well, what is the level of control and influence of the officers in this case? My understanding is there were no employees of the land management company that has been charged, and it was essentially the 3 officers who have been charged, who all, entered into agreements. They had control, profited personally. So there'll be, some kind of analysis as to, well, what were these officers doing and what is the requirement in these circumstances to discharge their due diligence obligations. I think there will be discussion as to what are the requirements around allocating resources for health and safety risk management. It might come down to looking at, well, what is the size of this entity? What is the profit? What's the spending of that organisation? Have they engaged external experts to come and give them expert advice around health and safety risk management or the activity that is being undertaken on their land? So that will be interesting to see that unfold. The key, I think, given the way that WorkSafe have charged in this case, is the overlapping duty holder requirements and what the 3 C's around consultation, cooperation and coordination looks like in practice. Here, there will be discussions around, well, were the roles and responsibilities in terms of management of risk clearly defined? Did people know what they were doing and what was required of them? If there were contractual obligations in place for, someone to be providing, safety information to a tourist, what steps were being taken by one party to make sure the other was doing what they expected? There will also be consideration of the sharing of information. So what information needs to be shared between the various duty holders. Another theme that has come out from the prosecution is that better communication, essentially, between overlapping duty holders allows for informed decision making, better risk assessments, and then essentially better understanding as to the risks and how to manage them. So the whole sharing of information, what is shared, how it's shared, how that information is reviewed between the various duty holders will be.
Olivia, we're probably running out of time, unfortunately.
Am I up against the clock?
No,
sorry.
Sorry, no, we have a few questions early on, so that's fine. Just a couple of questions coming through. Perhaps on a Whakaari, do you anticipate any problems with WorkSafe in pursuing Whakaari prosecutions, given their role in carrying out safety audits for venture tourism operations?
Yeah, so my understanding is that there are 2 separate inquiries into that. Well, MB's undertaking 2 reviews. One is that regulatory regime for venture activities, and no doubt there'll be some changes there. And then there's also an independent review into WorkSafe's obligations. So those are 2 pieces of work that are still underway, and we wait to see what comes out of them.
Cool. There's a couple of questions here which I'll combine, which is really around the earlier comment around commuting and to and from work and what is classed as work. If your employee does a 12-hour day, how do we manage that if they're tired before they go home? What is the definition of commuting? Sort of what is that definition of travel, I suppose? Will it always be at work? So
Yeah, so the case Sarkinson didn't actually define, what is commute, but I suppose there'll be essentially work that you do then does impact on your travel. So if you are then fatigued from work and then you have an accident, I'm not aware of any case looking at that in a personal capacity. Say you are then driving home from work and it's your work that then is impacted on your ability to safely drive home. How WorkSafe would look at that. That is, though, a factor in terms of impacts of work on health and how the two are interrelated and impact on each other. So you would need to be engaging, I think, with your employee in that case and making sure that they are fit to drive home.
Cool. Here's one here about versus the US. Do you see the outcome of prosecutions being used in civil action against any other parties in other jurisdictions, i.e. personal injury claim in the US?
In terms of Whakaari, or?
I presume it's Whakaari, yeah.
Yeah, so my understanding is that there is prosecution in cases being taken in the States against the cruise liner, and in Australia. We obviously have our accident compensation regime that prevents people bringing civil claims for personal injuries in New Zealand. But obviously there is what some people term as a backdoor to get around that in our WorkSafe HASWA sentencing regime, where you can actually have reparation awards for consequential loss that has occurred as a result of offending under HASWA.
Cool. I think those are most of the questions. Any other final? We've got a couple more minutes. Any final? Oh, here you go. There's one coming in. This is around workplaces and IT equipment at home. What would your advice be to employers who are currently grappling with the issue of who pays and supplies the workstation equipment and IT at home for remote workers? So basically, who pays for the kit?
Yeah, it's a tricky one, and even we're grappling with that. So I think it comes down to if it's elected, so it's not a requirement that the employee is not required to work at home. So you've got to provide your employees with sufficient tools to undertake their work. And if you are directing your staff to work from home, then there may be an obligation on the employer in that case to essentially pay for the costs of them being able to work from home. But if it's not a requirement and you've got an employee who's electing to work from home, then that's another discussion as to who pays for what. Yeah.
Okay. I guess that's about it, I think. Thank you for that, Olivia. Sorry?
Yeah, just finally, I just wanted to touch on one of the aspects of Whakaari that I didn't get to, which is the provision and communication of the safety and risk information. And that is the government departments that have been involved here, but all of the parties involved. And I think that is going to be really useful, because there's lots of comments that have been made around, well, what is the information provided? Who is it provided to? You need to consider kind of language, literacy, understanding. Is it communicated in an effective way? So we're looking about safety alerts, risk management, who needs to know what information is provided to who's the audience, those sorts of things. So, that is going to be a key part of this prosecution as well, which I think is a good takeout that organisations can do now, then can look at, well, how do you communicate with your overlapping duty holders? How do you communicate with your workers, stakeholders? Is the level of communication effective? Is the understanding? The key part is the understanding. Is there enough information that is being disclosed? And if there's not, when do you need to follow up and ask for more information? So that'll be interesting to see whether the court lands on that, particularly with NEMA and GNS, because for them it's around the sharing of information and effective communication of risk.
Thank you, Olivia. It was a great presentation, and we have to wrap up now. I'm sure we're here with another 2 hours. We get to going. I'm interested in stats and your comment on stats, your comments on the commuting and the recent cases and Whakaari White Island. So thank you for that, and appreciate your time today, Olivia, and appreciate everyone joining the webinar. We'll be sending out a link shortly with the presentation and the recording for those who weren't there for all of it. I trust you have a good day. Take care out there.
Thanks all.
Thank you.